Hello.
Yeah. Good morning, good people. Is everybody in the classroom right now? Okay. I hope we have the majority, I think. Do you think we can start?
Yes, Doctor, I think we can start.
We can start now. Thanks so much. Okay, good morning, everybody. I welcome you to this class. IHL is taught in 45 hours. So for the semester, it is very rigorous because we have to cover so much within a very limited time. Usually, we have been spending a lot of time on the historical background, maybe the sources of IHL, and maybe the case law and many other things. But this time round, I chose to give it somehow a different approach in the sense that one thing is the law, that is what is stated within the 4 Geneva Conventions and the 3 additional protocols of Geneva. But alongside the law, we also need to be aware of the principles. The principles of IHL are well stated in the customary humanitarian law, that is international customary humanitarian law, as well as you find them across the 4 Geneva Conventions, as well as the protocols. So the additional protocols are meant as well to deal with issues that emerge in the due course as the world is developing and areas of armed conflict also keep on changing. And even the so-called the battlefield is changing. So different concepts are changing and new concepts are emerging. I find that one very interesting and as well very critical. And I do believe that you spend some of your time to go through the course outline, but most importantly, to do the readings that are recommended because you have a huge amount of literature that you can ride on in order to get IHL clearly and to become experts in the area. All the same, I've given you also an approach in which I share some of my video lectures, and also you are required to attend the lectures. So having all this and having the fact that ICRC avails so much of the legal materials online for free, and you can download them in form of PDF for free, and you can read them in order to know what they are addressing. So you have a lot of knowledge out there. The question is not having the knowledge. The question is, what do you do with the knowledge? So it is just to start you up and to ensure that you are coping up with the readings and the lectures. Now, I want at least one person in the group to take us through what we did last time, please. Anybody? Any volunteer? Anybody who has done some reading or anybody serious?
or Mwalimu or Daktari, maybe we picked what we gained most, so that it becomes like a merry-go-round, everybody speaking, and then we jog each other's memory.
No problem, but I just want one person. Even you yourself, you can start us up. Give us a summary of what we did last time, quickly, if you can.
Okay, Mwalimu, not necessarily a summary, but then there's something that I got much was that what is coming out from the distinction principle, where we talked about the military objectives and civilian objects, and we also talked about military necessity, and that in case of a war, and then the war should take the shortest time possible. And we also talked about the principle of proportionality, in that when one is aggrieved, then the use of force, the force with which he will respond with, should correspond to the nature of the instigation. That is much. Of course, not all, but that's part of what I remember from our last class, Dr.
Congratulations, congratulations. It is already good enough that you can recall the principles that we have covered. Now, I want to finish with the principles today and get you to understand other areas, because we are dealing with, we have dealt with the, let's say, the hostilities, and how to apply IHL during the hostilities. We have looked at the law protecting the civilians, and that is under Section 5. Section 6 indeed is supposed to deal with the protection meant for the combatants and the prisoners of war. Then we are going to another session that is dealing with women and children. Then we'll also be looking at, let us say, the type of rules or type branches of law that you need to look at in case you want to invoke IHL in any material case you are involved in. Then the emerging issues, and it is very important that we are dealing with emerging issues such as the war between Israel and Hamas, or Israel versus Hamas, and the war happening right now between Russian Federation versus Ukraine. These are still the outstanding wars, and they are very complicated as we know them. And it is always good to remind ourselves of these principles. So we have talked of the principle of distinction. That is good, and you have rightfully put it. The military necessity, we have talked of that as a principle, and it is good you have stated it. And also we have talked of the principle of proportionality. These are key principles of IHL, but not only. So today I would like to talk about the principle of precaution. And precaution I'm going to link with other elements from distinction. And again, we are going to talk about another principle, that is the principle of neutrality and how important it is for the IHL. Then finally, I will be addressing the principle of internationality. That is the application of IHL at the international level, the universality aspect as well. Now, let me begin straight away and address this issue distinctively so that we can again get back to our sessions. The principles are as good as the law, and they are these principles that you use for litigation. So when we teach IHL to lawyers, it's not as when we teach it to media practitioners or when we teach it maybe to other entities. So when we teach it to lawyers, we focus majorly on areas of litigation and also how to use that law in order to defend or in order to represent your client. So in this case, let us begin straight away with precaution. What is a precaution? Precaution is an outstanding principle of IHL, and it is one of the ones we have talked about. And precaution simply means that in case of any decision to be taken by military for a legitimate target, they need to ride on the precaution as the principle. The precaution as the principle shall entail such things like avoiding, let us say, the undesired or the untargeted consequences of the attack. So let me say this: if you want to attack your enemy, you need to ask yourselves the following question: will the weapon I'm going to deploy achieve the military objective? And is there military necessity? These are the questions any commander or somebody who has responsibility on behalf of others must address first and foremost. The reason why we talk of these principles, these are the principles that will inform your litigation and arguments in any court with competence and with the jurisdiction over international crimes, such as crimes of war, crimes against humanity, crimes of aggression, crimes of genocide. Now, let us say precaution stands for being careful, but also it is taken to mean having duty, or let us say owing duty to the other person. So that kind of responsibility that you owe to other people, or the duty you owe to other people, is about the precaution, in the sense that even that weapon you are using should not damage the environment. For instance, if maybe you use some chemical weapons that will destroy the flora and fauna or destroy the biological ecosystem of a certain region, that humanity will have to pay the price, even the ultimate price, then that is the principle of precaution. So the precaution is a very important principle in this matter when it comes to making decisions on what type of weapon to deploy and what type of weapon not to deploy. Another thing is that that weapon you are deploying will not, let us say, spill over to destroy the civilians or those who are not participating directly or indirectly in the hostilities. That is still principle of precaution. So precaution just means you're bearing some responsibility while making decision on any legitimate target. So let's say you want to target a military objective, let us say to destroy a military camp, because inside the camp, you know very well that maybe some tanks, armored cars are stored, and lots of ammunition. And for you attacking and exploding the area, of course, you have weakened the enemy. So your military objective, first and foremost, is to weaken the enemy and to bring the enemy to a situation of surrendering. But in order to do this, you weaken those, let us say, facilities. So those facilities, known as military objectives, are your legitimate targets. But by attacking these legitimate targets, you need precaution. To what extent will my action spill over or violate IHL or violate the interests of other persons, and including the environment, including the cultural sites, such as monuments, cultural monuments, or the history of the people? or maybe destroying religious sites like churches, synagogues, or maybe mosques, or any spiritual or areas of worship. So these ones also have been prohibited by other conventions. And there are many other conventions, by the way, like the Hague Conventions. And that one is something parallel, but not the same with IHL. So, mind you, we are dealing with two branches here that you need to know what belongs to the Hague Conventions, which also generate a lot of rules meant for the military actions and military operations. We will talk about that separately. But when we talk about the Geneva Conventions or the Geneva Law, which of course is our interest, then we are talking of humanitarian law, the humanitarian aspect of the entire armed conflict situation. So the Hague is more interested in equipping the military with certain rules and regulations. There's no problem about that, but also regulations concerning conventional weapons. Instead, IHL is more interested and concerned with humanizing war or humanizing hostilities or such conflicts that amount to warfare. Now, the principle of precaution is measuring on what we call bearing responsibility at law. And in that case, it is also a duty on the part of the commander. That's why we talk of the principle of commander responsibility, that the commander bears the responsibility over every action taken by the members of the military during the hostilities, during the war, or what we call jure in bello, or during the hostilities or the exchange of hostilities. So in that case, the responsibility of the commander as a principle emerges and materializes in most of the cases that have been so far presented at the ICC on the violation of or commitment of the war crimes or the crimes against humanity, to an extent that commander responsibility is also a very key principle. And it emerged mostly during the Balkanic War that broke up in 1990s with the collapse of the Soviet Union. And most of it brought new concepts into the IHL law and jurisprudence, in the sense that those entities were existing as communities. So like when we talk of Bosnia, Herzegovina, Yugoslavia, Kosovo, and those other small communities, the fight was based on communities. And now the question was, would a community assume the status of a nation? The answer became yes, and that is again changing the entirety of the concept we had before, that the combatants are those who are employed by a government. Because here, these communities were not governments, because they were occupied by the Soviet Union, which became an empire, and these things were like confederation, and they were existing as confederal communities. So that means they had their administrative units, they had their sort of governance, and they were existing like that during the time and leadership of Joseph Stalin. And when the case came up at The Hague, that is ICTY, that is International Criminal Tribunal on Yugoslavia of 1991 and 1994, most of the cases that were invoked were meant to deal with the community violations. So how could we now consider those who are fighting as combatants unless we graduate those communities to the status of a government, of a reality with somebody responsible? Now, that is what brings us again to emphasize on the concept of commander responsibility. So whoever is officially declared the commander of all the others will bear the consequences. And we find it in many cases, even that one of Milosevic. But Milosevic's case was that Milosevic was a president. And being the president, he commanded some killings and violations of IHL. And that again brought him into the limelight of the prosecution at The Hague later. And he died there before the trial began. So all these once again amount to the case law of IHL, and we need to get to understand it. So commander responsibility is amounting to the principle of precautions. So you need to take care or to take measures of what your operations and the orders you give as the commander to your juniors, and if it will violate the law or not. We see it happening again, and history repeats itself in the several attacks of Israel, of Gaza, and so many cases of civilians being killed through bombardment, maybe air bombardment, and even including humanitarian workers, even United Nations officials. And this is again the question of violating the principle of precautions. If at all you are aware that your enemy is in the group and you want to eliminate the enemy, do you have to eliminate the entire crowd? That is the question. One, a legal personality of IHL would ask himself or herself. Now that is precaution. Let's move faster and get to another principle known as neutrality. Neutrality as a principle is well known, and Switzerland is known to be a neutral state worldwide. And that is why most of the peace meetings or peace negotiations, diplomatic negotiations are held in Geneva. And that is, again, I don't want to maybe to preempt. That's why Geneva still stands out to be the best place to have certain major organizations headquartered because of that neutrality principle. Neutrality, when it comes to Switzerland, is just to say that they are neutral to any international politics, they're neutral to any international wrangling, and anything to do with war. They are not going to be a party to any alliance. They are not forming alliances. And that one was witnessed even during the Second World War. So that neutrality, which is very strategic for Switzerland, in the sense of having confidence of the parties, has also been a very, I would call it a clever principle for IHL. Now, why do I say it is a clever principle? It is a clever principle in the sense that IHL operates on it to ensure that it is not going to be judged by any party. Being neutral to any party and being apolitical in any warfare makes it easier for IHL to be respected and to be promoted and honored by the parties. If at all you have participated or you have attended any of these conferences, you would have noticed that the belligerent parties are always very bitter. I wanted also to recall to your attention what is going on right now among university students in Georgia, in the United States of America. And they have started demonstration against genocide that, according to them, is committed by Israel just at our watch. And these are university students. So the regime, the government is trying to fight them back, even to threaten the students for suspension and maybe severe punishment and arrests. And some have been arrested as we are speaking. But even the University College of London, students are demonstrating. They are pitching tents outside the university premises, demonstrating against the Jewish state of Israel for what is going on in Gaza. But the same also is happening in Australia, in the University of Sydney. The students are up on arms, demonstrating peacefully to call for the international community to take action and stop the killings and this murderous action or butchering of the Palestinians. Now, I don't see anything happening on our side. Maybe we are too naive, or we are not interested, or we are not reading, or we are just there. But this is also something I would call the weakness of African states and African citizens, that we are there watching as spectators when the world is burning. Then we don't know which side we fall. And our students used to be very active, but only on political grounds. Some students started demonstrating, but just on behalf of sympathizing with the doctors on strike, which is already good because that is humanitarian. And they see their colleagues being tortured. And that is just a section of students. But our students of international law seem to be out of place and out of question. Nobody feels it is part of us and until it comes. So neutrality doesn't mean sitting on the fence or not participating or being disinterested, because it can also amount to our weakness, but also it can amount to ignorance. Maybe you don't know anything. And being a student of IHL, you need to be active in order also to inspire yourself. So that's not neutrality at all. That is a weakness. So neutrality doesn't mean you are weak. Neutrality as a principle simply means you are not siding with any party. You are neutral. You are not joining any political discussion about the matter. Now, when students are demonstrating against Israel, already that is not neutral. They have already taken political side. That means, in their view and perspective, they see that Israel is committing genocide, which of course is the argument taken to court by South Africa, but also by Nicaragua against Israel. And the cases are still ongoing at the ICJ and ICC against Israel. But all the same, before the court rules against or in favor, we cannot jump into judging Israel harshly and saying it is genocide and we are up on arms to defend the victims. It would again be equally undiplomatic on the side of the demonstrating students. But it is equally also good to bring the agitation to the public limelight through the social media and also through demonstrations that are published in the mainstream media, to call or to create more awareness or to create what we call public awareness. And in that case, it is like we are saying there is no neutrality principle there. Neutrality principle means that you'll not see IHL lawyers or ICRC members demonstrating, or maybe joining the demonstrators or supporting the demonstrators. Why? Is it because they know nothing about it? No. It is simply because of the neutrality principle, which means you want to have confidence, and in good faith, you want both parties to have trust and confidence in you. For instance, Palestine and Palestinians have got no faith and trust in Europe, and they do not have any faith and trust in the United States of America. Why? Because both European leadership and the United States of America have demonstrated their full support for Israel. Now, if you are to go to seek justice and you find it is America which is the judge, and you are a Palestinian, you will withdraw, you will shy away because of one fact. You cannot be a judge in your own case. You have already taken side, and how can you prove your neutrality and impartiality? So the principle of neutrality is very critical. It is critical also to the damaging extent. Why do I say damaging extent? Of the emergence of the new style of war, that is the emergence of terrorism or international terrorism or transboundary terrorism or organized terrorism, if you wish, especially by Al-Qaeda. So when Al-Qaeda was crafted, already we had terrorist approach to any warfare. But this was not known so much in 1949 when the four Geneva Conventions were adopted. And it came to be known mostly, especially when Al-Qaeda attacked the United States of America. You remember September 11th, I think most of you are already born, 2001. And in that case, America declared war on terror. So by declaring war on terror, I'm talking of war. I'm not talking of just anything else, but war on terror, which of course got some support, especially from the United Nations Security Council members, and a resolution was passed to allow America and its allies to move to Afghanistan, another sovereign state, and attack it militarily, hunting for Osama bin Laden, or the boss of Al-Qaeda. And you know what happened in 2003. And when the war was going on, and Osama bin Laden was nowhere to be found, and they destabilized the entire regime of the Taliban. At the same time, former President George Walker Bush decided to move the story, the entire effort, to attack Iraq under Saddam Hussein. Attacking Iraq under Saddam Hussein was not on the table, and that is not part of the resolution. And the claim was faked or far-fetched that was supported by US and UK that Osama bin Laden, no, not Osama bin Laden, Saddam Hussein was in possession of weapons of mass destruction. Weapons of mass destruction is what took America to Iraq, and America declared a war on Iraq, which of course Iraq could not defend itself, and Iraq was doomed. Now, what am I talking about? All these wars happening created so many violations and so many cases, some of which have not gone to court yet. And one of them is that one of the prisoners of war, because most of the captured fighters, within quotes, were taken to places like Guantanamo Bay, a small portion of Cuba belonging to the United States of America, and they were detained there. So what am I talking about here again? I'm talking about POWs, that is the prisoners of war. Some were detained in Iraq, Abu Ghraib prisons and camps, and they were like locked in those places. What emerged when President Obama took over from George W. Bush was that now what do we do with the prisoners? The United States of America had no jurisdiction to prosecute them. No any country was willing to take the suspects or the prisoners to court, and they had to be released. But even by doing so, the damage had been done and crimes had been committed. Now, what was the problem? The problem now comes in when we consider the question of terrorism, whether terrorism has been defined within the international criminal justice system as a crime, and what is terrorism. So by virtue that even under the United Nations auspices, there is lack of clear legal definition of as what is terrorism and what is not terrorism. That one brought about this kind of standstill. Another issue here that I would like to highlight is the neutrality principle, in which IHL, the Geneva Conventions, the additional protocols ride on the neutrality principle. And that means neutrality principle would not judge persons or prisoners based on the way they have been characterized. So if prisoners, some of them are members of Al-Qaeda, let us put this assumption, and you want to mistreat them because most of them were tortured, even in violation of the Convention Against Torture at the international level. And you want to consider IHL here. And IHL rides on neutrality. IHL will not discriminate against an individual because he or she is a member of, let us say, the criminal organization, that is Al-Qaeda. So that neutrality principle, the question is, does it now favor terrorists or it is criminalizing terrorists? So it is neutral. That is all we know. But the debates are ongoing, and this is a very controversial topic at the international level. So let us again move faster from what happened at Guantanamo Bay prison and Abu Ghraib and justice that was supposed to be done to the detainees as per Geneva Convention number 3. That is the protection of the prisoners of war. Now, we move to the neutrality looked at from the political angle, in the sense that any point in time, you demonstrate as a lawyer or as a jurist that that branch of law has got some political insinuation. You have already created an enemy and what we call mistrust and rejection. And that is where IHL succeeds to be relevant. in all types of armed conflicts as they emerge. If not that way, it would be very difficult to persuade any high contracting party to have confidence in the justice system, but even to accept any truce or any peace as it is happening right now between Israel and Hamas, because of lack of confidence in the justice system that may not persuade and convince the parties. So that is, we will say more about neutrality. But let us again look at the internationality principle and universality. When we look at internationality principle, that means IHL can be applied internationally, and it is a branch of public international law, and the states or the parties that have ratified the conventions and they have ratified also the additional protocols are subjected to the obligations under the treaty law. So having that fact, that is a treaty law regime, it applies mainly to the countries that are parties to the treaty. And those parties are under obligation to apply and enforce IHL. But how about states that are not members or that have not ratified or are not signatory to the 4 Geneva Conventions and to the additional protocols? What happens to them? Let's say, for instance, I'm giving you an example just for you to understand and capture the idea of internationality. How about North Korea, the regime of Pyongyang, where a lot of crimes of war are committed and crimes against humanity are committed? Wouldn't we apply IHL in such a situation? The answer is affirmative. We would apply IHL there. Under which principle? Under the principle of universality. Universality. So I want you to distinguish between internationality and universality. Internationality is just internations. Those means the states that are signatory to the treaties. So they are bound by virtue of the treaties, as those who have ratified it, by those treaties, because it is under treaty law. But if you are not a signatory to the Geneva Convention, you are still bound to respect and enforce IHL under what? Universality. And that is why, again, you cannot escape from being bound by IHL as somebody participating in any hostility because you belong to a militia group, or maybe you belong to a terrorist group. So you think that IHL is not applicable to you. It is still applicable to you, even if you're not a high contracting party. Why? Because of the principle of universality. Where does it come from? I refer you back to the common Article 3 of the 4 Geneva Conventions that emphasizes on humanity. Humanity is not owned only by some people or maybe some individuals, not by dynasty, not by hustlers, not by somebody in a certain political class. Humanity belongs to all of us by virtue that we are members by nature of the human society or human community. So that is what humanity is all about. So humanity is a universal reality. So being a universal reality, it still makes IHL applicable, erga omnes, to all members of the humanity in disregard. So whether your state is a signatory or not, or has ratified or not the Geneva Conventions, still IHL is applicable. Now, I don't want to talk about benevolence because benevolence is a principle, but for ICRC, benevolence is the principle of Red Cross or the International Red Cross, Red Crescent, Red Diamond, Red Lion. And that is where you see even Kenya Red Cross engaged in those who have been faced with the overflooding disaster in Nairobi, in Athi River, and worldwide. Or what are they doing? They are doing what we call benevolence, which is just another aspect of the reality of the Geneva Law. But since it is nothing to do with armed conflicts, IHL is not called into question. Good. Back to our questions. Now, let us again agree to disagree that having these principles, such as military necessity, principle of distinction, principle of precautions, commander's responsibility, having the principle of neutrality, internationality, universality, we can now deal with many pragmatic questions that shall be given to us at the examination, because it is through these principles that you will be able to construct any legal brief or any document that you'd like to file in court as a lawyer in defense, or a lawyer maybe in prosecution before court, or anything you can consider as judicial opinion from the bench, and look at it also from the horizons of the international law, in the sense that the jurisdiction of the ICC as the only international criminal court or international criminal justice system. So far, so good. So these are again reminding us of the evolvement in war, or in the concept of the armed conflicts, and how things are changing and evolving with time, up also to the extent of looking at it from the environmental perspective, because you can use environment as a weapon. So let's say you destroy maybe a forest, and that forest will not be there. And how you will do it, you know. What are you doing? Already you are fighting those who rely on the forest to survive. Maybe the members of Ogieki family, or maybe the entire humanity that ride on that type of natural environment, maybe for the rainfalls or to capture rains, but also to protect soil and land. So war can be fought in many ways. So environment can be one of the weapons, and it can be weaponized against the enemy. Women have always suffered in many of the modern warfares, in especially civil wars, but also the so-called international armed conflicts and non-international armed conflicts. Why women? Why women? By nature, women are very reproductive, and doing away with women may weaken the opponent or the enemy, because the lesser the women are, the more the reproductivity of that community will go low. But also women have been subjected to rape, and such rape can also be weaponized, because when the enemy rapes women of the other enemy, of the other party, they rape them not to torture the woman, but to impregnate the woman, so that the woman will give birth not to children with the genetics of the enemy, but the genetics of the opposite enemy. So it's a wrath, it is a weapon. So that means you are weakening that community by raping their women so that children that will come or that generation will be not upholding maybe the opinions or maybe the desires of that particular community. That could as well be a serious weapon. And we have seen it happening between Russia and Ukraine. You know that the point of contention is about the eastern border, in which Russia claims that the people speaking Russian belong to Russia by right, and that means they are not going to be moved, only that they are going to move the border to increase the border inside Ukraine, something Ukraine is resisting militarily. And this as well has been documented when President Vladimir Putin was indicted at the ICC. He's still indicted and put under arrest warrant, and nobody is going to arrest him anyway. But the charges against him includes also the transferring of Ukrainian children into Russia to be, let us say, indoctrinated into Russian. So they fight and defend Russia. So it is like exploiting children and weaponizing children. That is another weapon. So there's so many new tactics. So these are the emerging issues. That is another session that will not be delving in because we have anticipated it, but it's helping you also to engage with the reality. Another thing I want you to get here is the deployment of the use of the so-called PMC. These are private military companies in which certain governments, instead of putting their official armed forces in the front line, they prefer PMC. Why? Because PMC are people who are hired. For instance, Kenyans, there are so many jobless, energetic young men and women. Some are even degree holders. What do you do with them? Create a company limited, train them into military jobs, and train them how to handle weapons. And they can be hired by any country. So these are the so-called machineries, and they are working. Now, this is illegal. We call them illegal fighters. So these illegal combatants, officially, they have been used by Russia against Ukraine. You have heard about the Wagner Group. I'm not telling you something new. Members of the Wagner Group are not paid by the government of Russia. They are not even known to begin with. These are just private people, only known to the oligarchy or people who are close to Putin, and they are used to weaken Ukrainian soldiers because they will not respect and observe the international law of war. They'll not respect and observe IHL, and they can do the impossible. That means they can violate these rules. And now, when you as the international lawyer, you open an investigation in order to indict Russia, then you find no Russian military involved. This is where the trick is. And it is a trick. And that is why Putin cannot be found anywhere when it comes to those violations of IHL. Why? Because he is smart. He has used the machinery to fight the war, and these are illegal fighters. So the illegal fighters fought and weakened the opponent to an extent that now Ukraine is even running short of the fighters because most of his fighters have been killed or they have surrendered. So in that case, it is a serious issue at the international level. Now, if we again look at PMC, we see the same Putin deploying these kind of illegal fighters on Africa, but not to fight or not to participate in any war, but in Africa to smuggle wealth, to smuggle resources. They are there in Mali, they are there in Burkina Faso, and also they are there in Central African Republic. What are they doing? And it has been observed that there are aircrafts departing and arriving in those parts of Africa on a daily basis and carrying out gold and diamond to Russia. So having this kind of tactic, that means they're thugs anyway. But since African leadership is so vulnerable and weak, African leaders, being politicians, they just want Muzungu to protect them from their political rivals. And they can kill the political rivals just at no payment. Now, back to the story. From a lawyer's perspective, how would you indict such a person? Where is the principle of commander responsibility? Who is the commander? This is where now we get again engaged into emerging issues that are very sophisticated at IHL, because these are not official fighters. They are Russians because they speak Russian, but they are private people and they are working as a company and being paid privately. So there is no way you can get and come up with documentary evidence that they work for the Russian government, and you cannot attach them to anything to do with the Russian military. So this is, I've given you different issues, just to open you up to the emerging issues. Now, I want us now to proceed from here, because it is a session that we are not going to discuss. It comes almost at the end, but we have dealt with it today. But it is going to help us engage appropriately with these other important sessions, such as the protection of women and children, the protection of civilians, the protection of combatants and prisoners of war, and all the rest. Good. Now, I want now to start engaging you as we did the other time. And I want you also to write on footnotes and help yourself with the readings, because that is what you're supposed to do before we finish. So I want us to begin by asking questions. Is there something about these principles I've talked about that you want me to explain or to elaborate, illustrate more? Or is there any comment, something you want to add before we get into certain debates?
I have a question, Dr. A.
Please come on.
And it relates to the principle of internationality and universality. If you don't mind, could you kindly elaborate more on that? Because I see that in a way the two might possibly be interconnected.
Okay, good. Yeah. They may be, okay, they may be understood to be interconnected. That's why I was like treating them like together, but they are not the same. They are not synonyms anyway. Now, for legally speaking, internationality as a principle under IHL simply means what we understand about the treaty law. And the states that have ratified and signed into law the Geneva Conventions, the 4 of them, and also the additional protocols, are by right and by obligation members of IHL, and they're under obligation to apply and respect and also command respect or urge others to respect IHL. So that is internationality, in the sense that should such a state go into war or get into war, God forbid, then it is obvious that IHL is applicable in that case because of internationality principle. So internationality here is reduced to the understanding of the treaty law, that the treaties bind upon the signatories. The treaty law is like the law of contract, because whoever is privy of the contract is the one that can enjoy the rights, but also can suffer the obligations under the contract. But whoever is outside the contract is not affected by the contract. The same applies to the treaty. So a state can make the following excuse that since we have not signed the Geneva Conventions, and since we have not ratified Geneva Conventions and we are not members of those conventions, we can violate IHL. Now, what kicks in is not anymore the internationality principle, but what kicks in is universality principle. And in that case, again, we go back now to distinguish between universality. So universality and internationality differ only in a very thin line. So the thin line is internationality just means that not all states, but only the states that have ratified the treaty. That's what internationality stands for. Universality instead stands for something again very interesting, that whether you have signed and ratified the treaty or not, still you are under obligation to respect and apply IHL. So that one comes from the concept of humanity, because IHL is designed around the concept of humanity. So humanity principle plays out here to define to us what universality concept is all about. I gave you the example of North Korea under Kim Jong-un. If North Korea is not a signatory to any Geneva Convention and is not a member to any Geneva Convention, does not mean that any violation that its members, let us say its military or its leadership commits, cannot be charged in court under universality principle. So this is where universality principle, riding on humanity under the common Article 3 across all the Geneva Conventions, which I invited you to read, there is the call for international approach, but also universality in the sense of humanity, but also in the sense of humane treatment of whoever is fighting as a combatant, but also non-combatants at the same time. So by virtue that that person is a human being, IHL is applicable in any case of violation or any case of his or her rights being violated. Have I answered your query?
Yes, Dr. You have, and maybe just to understand it even deeper.
Yeah.
So internationality means that, states are bound to the treaties that they have signed and ratified, whereas states that have not ratified or signed and ratified those specific treaties, it means that automatically they aren't bound to it. But then with universality, it's all about everyone being under the same law, which
Yes.
means that whether or not you have signed or ratified a particular treaty, it does not negate the fact that you are bound to it and are supposed to abide by the law.
Precisely, absolutely. You are very right. Remember, there was an event in Sudan when Omar al-Bashir was still the president or the leader or the dictator. And when Omar al-Bashir was indicted at the ICC, which of course arrest warrant had been put on him, Omar al-Bashir decided to expel all organizations, including ICRC, from Sudan, putting the following claims that they are smuggling in weapons or maybe they are spying on the government, because he was afraid of what was going on at The Hague in his case. Now, the question is, expelling ICRC from your territory does not justify you to continue or to be absolved from violating IHL. Now, you see, these are the tactics, and universality principle is very, very important in the sense that even if you withdraw from membership or from the ratification, or you say now we are not signatory to this treaty, you are still not safe. It doesn't warrant you to carry on with your criminal activities and violations of the international law. And that is where universality and internationality appear to be similar, but also they are not similar. Thanks so much. That's a very good remark. Thank you. Any other person?
If I may, sir, since I still have the floor, I have a question in regards to the commander principle.
Yes.
And my question is, we know that commanders usually issue orders to their subordinates.
Yes.
And as a result of the same, the subordinates have no option but to obey. But then what happens when a commander issues an order and the order is issued under duress? So I'll give a very brief example. Let's say the commander is supposed to, they have gone into state A and they're going there knowing that there are military personnel and they're going to attack the military objective. But then when they get there, apparently they were using wrong intel and they find out that, you know, this particular place actually has civilians, and the commander is made aware of that despite the wrong intel. But then the commander nonetheless says, no, let's bomb the place, knowing that there are civilians. And he tells his subordinates that if you do not bomb, if you do not, you know, kill these people, what's going to happen is your weapon will be taken away from you and you're going to be included amongst the civilians, amongst the people being killed. And now the subordinate here is caught in a catch-22 situation whereby they don't know whether they should obey, because if they obey, it means that yes, they'll be going by what the commander has said, but then on the other hand, they're killing civilians, which is, you know, against the principles of IHL. But then on the other hand, if they don't obey, then, you know, they will be termed to be disobedient. But then at the same time, they would also be, you know, protecting the civilians and going by the principles of IHL. So in this particular case, if they were to be taken to the court martial or something of the sort, they're supposed to be liable, and what's going to happen?
Very good. This is a very good scenario. And in this case, there is a very clear issue. The clear issue is that the military forces are designed under the theory of command. So the theory of command is order. And order means that what your boss has ordered you, and you are the subordinate, you obey it as it is. No question and no answer. If your commander tells you target, that means it's a legitimate target as per your commander's conscience. You don't need to question whether that is your mother you are shooting. You just shoot. And that is why the military people are also considered to be blind people. Why? Because being a military, you are just acting and working under orders. So you are right, because there used to be a practice, and it is also violation of IHL, that if a subordinate did not obey the command and order from the superior, that subordinate could be sanctioned or could be victimized and could as well be killed or be taken to martial court for adjudication and punishment, as you say. But in many cases, they are just shot by their fellow military people. Now, to save us on this, and you see the protection meant for the military or the combatants, it includes also respecting the dignity of individuals as combatants, in the sense that a combatant does not lose his or her humanity. That is the concept behind it. And in that case, a combatant, whether a woman or a man, can again declare something we call conscious objection. Conscious objection principle means that that particular combatant at any time, any given time, can declare rejection and also can declare hors de combat. So hors de combat, which is a French terminology which we use, means that you have surrendered. So you are no longer a fighter, you are no longer fighting, you are no longer interested in fighting, and you should be protected as hors de combat. So even if you happen to be arrested and you become prisoner of war, in that case, it would be in violation or in contravention of IHL if there is no humane treatment accorded to you, and if you are not accorded the respect of your conscience objection. So that is the reason why the case of Dominic Ongwen, I gave you that case, I think, one of the sessions. So, and somebody said, but since he was captured as a small boy and he was recruited when he was still premature, just a child, into this militia type of life, and it was like psychologically, that was what he knew about life. And if this one could really save him as defense during the proceedings. Now, the question is, during the proceedings, it is just sufficient to test that you are in your right senses and you are conscious, and your consciousness has never been interfered with, or you are not an idiot. And if you are in your right senses, that means you could as well surrender. You could as well, as early as possible, you realize that you are doing the wrong thing, declare hors de combat and be protected. If that one could be explained, then it would have just mitigated maybe the sentencing. Now, in this case, I find it very logical that the military people act under command and order. And whatever is ordered is what is done. And that is the military life. That one, there's no question, there's no problem. And that's how military works. But at the same time, law protects you in the sense that you can reject, but you can surrender. Rejecting and surrendering. You cannot just reject because you are rude. If you tell your boss, no, this one I'm not going to do, I can do what pleases me, then that one again is not what we are talking about. What we are here talking about is that you declare hors de combat. So hors de combat means that you are no longer fighting, you are no longer interested in fighting, and you should not be killed, and you cannot kill, and you lay down your weapons and raise a white flag just to show that your life should be saved. Have I answered your question?
Yes,
Hello?
Terry, you have, and you have brought a very interesting perspective. And I actually hadn't thought about it along those lines. So thank you very much.
Okay, welcome. Okay, other persons, other participants, ladies and gentlemen?
Yes, Mwalimu, good morning.
Hello, good morning.
This is Zedekiah.
Zedekiah, yes.
Yes. Mwalimu, I don't know whether I've heard you clearly, because when I remember last semester we did international criminal law, and also remembering the command theory that you have talked about as per international criminal law. And I remember we were told clearly that as per the command theory, it posits that a soldier is only allowed to obey lawful commands or lawful orders.
Mm-hmm.
And if, as a soldier, you obey unlawful command, which you know is unlawful or ought to have known that it was unlawful, then essentially you are on your own. The law will deal with you as an individual.
Mm-hmm.
Yes. So I don't know whether I'm confusing the two or it's just the same thing, Mwalimu.
Yes, Zedekiah.
Yes.
Now, that is what I've
explained.
explained. That's what I've explained just now to your comrade, in the sense that the military rules, there is what we call military manual. It is designed in such a way that you act under order. And when you join military, Zedekiah, you are now a civilian. Is that okay?
Yes.
Are we together up to that point?
Yes.
When you join the military, because it is of your choice and you are admitted to be a military guy, one thing you will have to do, and you have to, is to submit to them your civilian identity card. You will be issued another identity card, military identity card by the forces. You belong to the KDF, for instance. Now, that means your status, social status has changed, and it is you to be aware. Now, that means you have joined an organization known as Military Organization Worldwide that rides on the principle of order. You are acting under order, and what they buy from you is your obedience. If you don't obey, of course, you'll be sanctioned. You'll be punished. There's military police, I know. And also you can be subjected to military martial court, I know. But God forbid, war breaks out. And during the warfare is when now you will feel the pinch. Are you now telling me that now I don't obey the orders blindly as I was trained to obey orders blindly, but now I want to reason? I want to tell my boss that I can also choose what is legal and what is illegal. Of course, we train military guys on IHL and on what they need to do in order to avoid any legality that would again subject them to criminal prosecution. That one we teach them. So they are aware. But they are aware that that is illegality, but that doesn't mean that is going to overrule the military rule, which is the tradition of the military, to act under order. And that is where we have the principle of commander responsibility. Otherwise, if you want to argue the way you want, or the way you are saying that one can choose what to obey and what not to obey, then the commander responsibility will also cease to be there. Because the commander would say the following: I'm not responsible. I'm not bearing any responsibility on your action, on the actions of my subordinates. And that is why, again, to tell you why command or order as a rule is very significant. Why? Because the commander is expected to be somebody with his or her conscience intact, and somebody giving the command must bear the responsibility. So you, the junior, what is your role? To say that I'm not obeying that, that is illegal. You're telling me to commit illegality. You are already getting yourself into a serious problem. So the simplest and the legal thing to do is to declare or decombat, and you are safe. Because nobody stops you from surrendering. But nobody else is telling you, just stick there and disobey, because you will face the wrath. And I've seen some members of the military being subjected to physical torture, cold water thrown on them, and they sleep in the detention with water, with naked body. They're really tortured. Don't think it is something. I'm not kidding. I'm not kidding. I've had a brother who is a military, and I stayed at the barracks with him some years when I was a student. And I know that is how they work. And their rule is just order. And they know from the training, from the gate, you get from outside, you get into the gate of the military camp, you know now you are subjected to another jurisdiction. And that jurisdiction is order. Once you see your boss, you must salute him with respect. If you don't, punishment. Now, will you obey? Will you come up, Zedekiah, and say, no, I Zedekiah, this is illegal. It is against my morals. And no, you will be tortured. And you can even be punished thoroughly. Usually they are not fired. The reason being, military people have got a lot of secret and information about the security. So in many cases, the firing them is not the deal. It is just to maintain them or keep them in the military, in the forces, but ensuring that they obey the military rules. And it is order, obedience. So from the juniors is to obey, or insubordinates. From their bosses is to give orders. If you give a wrong order and your subordinate officer carries out and executes the action, it is you bearing the commander responsibility. How about your junior? Your junior may go free of charge, but if charged, the punishment can be minimal because he acted under order from the commander. But let us change the story, and the subordinate officer carries out an action which is illegal, of course, but not from the commander. What happens? This is, we call it double jeopardy. So double jeopardy means you did not act on command. That is why military guys can be armed to the teeth, and they have the rifles, and they see something wrong happening or a crime happening. They are just there with their guns. They are not shooting. They are not using the guns. No. Why? Because there's no order. Once they get the order, target, shoot, they will act blindly. That's how they work worldwide. So it is a question of understanding the jurisdictions. So the military jurisdiction is order, obedience. The opposite would be your conscious objection and to surrender and declare or decombat. But we are talking about during hostilities, not during peacetime. I'm talking, IHL is only applicable during wartime. So that also remind yourselves. So we cannot apply it outside war. The time of peace, apply other laws, but not IHL. Zedekiah, have you been answered?
Yes, Mwalimu, that's very clear. Thank you.
Oh, good. Okay, other people who have done some readings? Other participants?
Excuse me, Mwalimu.
Yes, Muturi.
Mwalimu, I was a bit fearing to raise my question because it is not related to what we are doing in today's class, but it is matter IHL.
Okay. No problem. Just bring it up. It can be of help to others.
My question is, when we are looking at the Chemical Weapons Convention, it outlaws use of tear gas in an armed conflict, where having maybe, like, for example, if you are to have the Kenyan KDF and maybe the Ugandan army. So it is true that you cannot use tear gas against any of the parties. But the same convention allows use of tear gas domestically. For example, dispersing demonstrators that we have been seeing all over. So my question is now, what was the rationale that it is around to be used domestically, but when it comes to armed conflict, it is outlawed?
Cosmas, Cosmas, listen carefully,
Yes, Mwalimu.
First and foremost, don't confuse what we are talking about with the crimes. When we talk about war, war is nothing to do with crimes. Crimes is something to do with police force and whatever. We are talking about military forces. We are talking about armed conflicts that are considered war within emphasis in bold or in italic. Now, when you talk about the prohibited weapons, and chemical weapons are one of the prohibited weapons, and you want to talk making reference to tear gas, I think that is a bit simplistic in the sense that what is tear gas made of? Can you tell me, Cosmas, what is tear gas made of? Maybe you have done some chemistry on the components of tear gas.
Sorry, Mwalimu. Okay, there's a gas that okay, I cannot remember it offhand unless I do some reference. There's a specific gas that is involved, and that is the one that is now make it to be an outlawed.
Now, the tear gas used to quell, let us say, the rioters, or to bring public order. That is by police. So we are already in another jurisdiction. We are no longer in IHL, and we are not talking about war. But what I know of is that wanatumianga pilipili, you know, those kind of things that can irritate your eyes, can irritate your skin. But when we talk of chemical weapons, Cosmas, don't be simplistic, please. It is something very bad. There are certain chemicals that can burn the body. They are chemicals, but the body can burn and can subject the victim to terrible pain. And that is what we call human suffering, and that is prohibited under the Convention of 1982. So many weapons that have been prohibited, they are in violation or in contravention of the principles of IHL, such as lessening sufferings, unnecessary suffering of the person. That is one of the principles. So when you talk of such weapons that have been prohibited, they've been prohibited on a specific ground. And it is true what you are insinuating, that chemical weapons are prohibited, the use, and biological weapons are prohibited in their deployment during any armed conflict. And also the same with landmines, the same with booby traps, and the same with other weapons like incendiary weapons. There are such weapons that have been banned, and that also we give credit to ICRC that has really participated in promoting the conventions that have outlawed the use of such weapons. So don't simplify it to mean tear gas. That is, I think, too simplistic, because I don't know how many Kenyans have received tear gas, even myself, especially during 2008. I was at the center of Nairobi, and the hotel where I was staying, Grand Regency, for 1 week, it was full of tear gas, sometimes during the day. And people could sneeze, people could cough, and that is it. It ends there, Cosmos. Is it a chemical weapon? Is it a weapon, really? I wouldn't put it, I wouldn't really graduate it to the level of weapons. So let's be serious. When we talk of weapons, we are talking of something that is destructive, destroying humanity. And I think it is lack of exposure, that the more we are not exposed to such armed conflicts and we are far from the reality, we try just to imagine. But let us stick always to IHL and its application, especially only during wartime. And if you want to bring tear gas there, then that is a bit simplistic. It is dismissed. Cosmas, are you satisfied? So
Mwalimu, I was asking that.
No.
Question is,
you go and read the prohibited weapons. There are conventions on that of 1982, and come back and tell me which tear gas and which are the ingredients. Remember one thing, that even the industries producing weapons are being regulated internationally by these agencies that must find out what you are including and must approve and disapprove. So you cannot use something that has been disapproved in order to get your way. So there is no way. So remember that there are international lawyers who are very investigative, and they are deployed to visit such industries that produce and generate ammunitions. So it is something serious. Let's not banalize it and bring it down to the level of tear gas. Tear gas, I think, is something, I don't know. It is just to smoke crowds out, but I don't know to which extent you want to compare tear gas with chemical weapons. Is that okay? Good. Okay, let's receive other commentators or people with questions. Okay. Now, silence means there are no questions. So let's do this. The other time we talked about the cat, and I told you I would be communicating with Sedekiah on the same, but also consulting with the faculty on the same. It is not going to be on Mutiani platform for one simple reason, that some of you have not registered and you may fail to do the exam. So since the CAT is very important for you, plus the coursework I told you is these interventions and your readings and participation in the debates, this is going to count for 30%. And I have decided that it will be take-home assignment, and there will be questions that you must respond to. And it is an open book. That means you can cite cases, you can cite laws, you can cite many things to make it rich. But I'm giving you 48 hours. 48 hours to answer 3 questions. 3 questions, each question has 2 questions. So there are 6 questions. So question 1 has got 2 components, 1 and 2. Question 2 has got 2 components, 1 and 2. Question 3, 2 components, 1 and 2. So it is designed to help you again engage with the study. But what happens when it comes to evaluation is something very critical. It is critical in the sense that it will demonstrate how much you have learned, but also your capacity and skills to apply and make good use of the legal instruments. Those are the conventions, but also to make good use of the case law, as well as the principles we have talked about in answering the questions. Once you have done that, make sure that it is persuasive and convincing, but it is your work. I don't believe that any of you will be doing something contrary, or will be doing copy and paste, or will be doing something that would be amounting to plagiarism. So all these things will be checked, and if found, then your work will be dismissed and you will get 0 instead. But if you use your head, your mind, your brain, and your capacity, you are going to be marked. But accreditation and whatever is going to be done will take into account also your active participation during the discussions. That one, there is no doubt. And again, the participation. Yes. Any question related to the CAT?
Yes, Mwalimu.
Yes.
If I may.
Please.
Yes, Mwalimu, thank you very much for allowing us to do the CAT on Google Meet, and also for indulging us in giving us 48 hours. Mwalimu, because of the commitments that some of us have, and also the fact that at the moment we might be doing back-to-back CATs, Mwalimu, may I indulge you in requesting that you consider giving us 72 hours? Kindly.
Yes.
Yes.
Now, I'm ceding too much ground because already it is not even going to be on Google Classroom.
Yes.
It will be through your class rep.
Okay.
Are we together there?
Yes.
So
yes.
I'll send the questions to your class rep that will avail it on your platform. I believe you must have group email or group WhatsApp, whatever.
Yes, we do.
Yes. Once you have done your work, you submit to him and he will submit to me so that I don't get 1,000 emails.
Okay. Okay.
Yes. I just want to get it from one source. Remember commander responsibility.
Okay. Okay.
So I must pin it on one individual, and that is Sedekaya Odhiambo.
Okay.
Who must bear responsibility. Sedekaya, don't feel
Yes.
tortured and scared.
No, I'm not. I'm not.
Okay. I know you are a man enough to bear the pressure.
Yes, I am.
Please do so. So this is what I'm doing also with other cohorts.
Okay. Okay.
It's a new thing, but I wanted to be lenient. So
Thank
since
you.
I'm ceding so much ground, I wouldn't put it to 72 hours. That one would be again like giving you 1 week.
No,
because I know how heavy and how difficult these questions are, but 72 hours would really be a bit exaggerated. Or what is the majority opinion?
Doctor, if I may come in,
Yes.
I think, yes, I may agree that 72 hours may be overstretched. But then, are we able to agree perhaps if we are able to know the exact commencement date? Because, yes, so that
That's
we
good.
plan adequately. We are having other cuts as well this week. That's why I think Zedekiah was trying to find a, a more lenient ground.
Good. Now, I wanted us to begin on 4th of next month.
That is okay, because the ongoing cut is on 3rd, I believe. So both we will be done with the other cut.
That is okay. That's in order. And it will not interfere with our class. We will be lecturing and attending lectures just as usual. I'm not going to cancel the class because of the cut, because it is not a sit cut. If it is a sit cut, then it is different.
Okay, Mwalimu. So as per your direction, if you are sending us the questions on 4th, so it means that you need to have all the answer sheets by Monday.
By Monday. Monday is which date?
Monday is on 6th. No, sorry.
No.
Yeah, Monday is on 6th.
Okay, because I thought 4th is Saturday.
Yes.
So I was talking of 4th because that's the day we have, but I can as well do that. We can start on 6th.
Sorry?
We can start on 6th.
So you send us the questions on 6th?
Yeah, I think that is in order, because if I send it on 4th, then on 5th is Sunday, I would be maybe interfering with some Christians who take Sunday to be a day of worship.
Okay.
Yeah, so let's agree that Monday is okay. It is in order.
Yeah, so we received the questions on Monday. Then by Wednesday, you need to have received all the answer sheets.
Yes. Is that sufficient?
Yeah, that's okay, Mwalimu. That is very sufficient. Thank you.
Okay. I'll even send on Sunday night. That is on 5th night in the evening.
Yes, please.
Yes, so that by Monday you just start the activity.
Okay. Thank you, Mwalimu. Thank you for the indulgence.
Yeah, please.
For me, I have a request.
Make it.
Looking at the nature of my work,
Mm-hmm.
to be honest, I might not make it. I'm okay with doing it over the weekend, but I find I might be inconvenient.
Is that Ngala Quinta?
No, I'm Jackie Maina.
Jackie Maina, okay.
Yeah, if it is sent on Sunday.
Yes.
Just the nature of my work, Monday, Tuesday, and Wednesday.
Mm-hmm.
I might not be able to submit, but if it is sent, let's say over the weekend, I might get time to work on the same.
Okay.
Yeah.
Good. So let's see if my suggestion was the best, because I was suggesting on 4th before it was pushed to 6th. Could we still maintain 4th?
If I may, Daktari.
Yes.
I will just like to, I hear what Jacqueline Miner says, and her opinion is very much valid, and I'm not trying to negate it in any way. But the moment we are doing exams on Sundays, and Sundays is our day of worship, and then on Saturdays, today, I'm sure that, the Seventh-day Adventists are rushing to go to church, or some are actually attending classes during, the church service, finding place outside. I honestly think, not trying to negate Jacqueline, but I honestly think it might be unfair, specifically working on an exam on a Sunday. Just my thought.
Okay, good. Now let's try to find to find a solution to this, maybe the middle ground. Now, how about if, let's say, you start on Monday, then you submit maybe by Thursday or by Friday, let us say that.
Yeah,
Just
Friday is fine.
just to stretch it a bit,
That is the fairest of positions so far.
Yes, I think. So that somebody like Jackie, who may be too busy, may have maybe some little hour or some little time to dedicate for the work. But I think if we, Monday to Friday is reasonable, eh?
Yes, it is.
Yes, Mwalimu.
Okay. That is from 6th to 10th, eh?
Yes.
Good, from 6th to 10th. So let's say on 10th is when I receive the scripts from Sedekiah.
Okay.
Okay.
Yes.
All right.
That will be okay.
Yes, yes.
I hope my comrades have heard that.
They have heard it clearly, eh?
Yes, yes.
Okay, good.
Now,
Now,
Thank you,
sorry,
Mwalimu.
yeah.
what time will, okay, what's the deadline for Friday? By what time should we send it to Zedekiah?
Now, you want us to agree?
If you,
I think by midday, because Sedekiah will not take too long to put them together and send to me on a folder.
okay, sir, that's well noted.
I think by midday is okay. We already have too much time. Okay, good. I think for today, I don't want to add much. For today, we have exhausted all the principles. Somebody talking?
Yes,
No.
Malim.
Yeah, please.
This is Ibrahim.
Ibrahim, yeah.
Maybe a final question, and you will also pardon me in case I will be asking a question that you addressed in the previous classes. Malim,
Yes.
my question is in a conflict, in an armed conflict, especially non-international one.
Yeah.
I find civilians also participating in taking arms or crude weapons like machetes. This I noted in Central African Republic when there was some violence there between government and some militia, I don't know what it was called that time. Malimu, now if this militia now are taking weapons from wherever they get from, or crude weapons for that matter, will they become civilians or they are now like militia? How will they be treated? And are they protected in that case? Yes,
Okay, good. Thank you so much, Ibrahim. This question has also come up in some of our high-level consultation conferences with ICRC. And you are mentioning crude weapons. And you said machete or knives. People are being knifed or people have their necks chopped off. We have such situations happening in various parts of the world, especially in Africa. Would they really be considered, let's say, as violators of IHL? Now, let us again look at another aspect. I've talked of weapon, and I'm also talking about what you said, they are civilians participating. So being civilians participating, but using crude weapons. Now, are crude weapons considered as weapons under IHL? That's a very good question. And addressing it, I remember when we had a meeting, ICRC expert, a legal advisor, refused to accept that such things like machetes, kitchen knife, or stones are also incorporated in the concept of weapons. And that one already has answered your question. But if somebody is using maybe light arms, like pistols or rifles or whatever it is, then already we are talking of arms under the context of IHL. Or maybe heavy weapons, such as armored cars, or maybe tanks, or is using an explosive that may be big or small in size. As long as the weapon that the person is using is recognized under IHL, we can already start our kind of evaluation assessment, whether we can apply IHL or not. Now, let us change the topic from the knife, the use of knife, machete, to the use of rifle or the use of a gun. That already we are entering the question of the weapon in the true sense of what a weapon is under IHL. So in this case, we can start by analysis, by saying that when we are talking about the concept of combatant and non-combatants, and saying combatants are military forces that are employed to fight and to be fought, but also to kill and to be killed, versus non-combatants, who are the civilians, who are not supposed to fight, they are not supposed to be killed, and they are not supposed to kill, and they are not supposed also to be fought. So in this case, there is a clear distinction, the principle of distinction between the civilian and the military. Now, if a civilian, and it is during the time of war, there is time of war declared, and a civilian picks a weapon and fights or participates directly or indirectly in the hostilities, that civilian is considered as a civilian who has lost his status as civilian and cannot be protected under IHL as civilian. And in that case, the person will still be protected, but as a fighter, not a combatant, but as a legal fighter. A legal fighter, that means he was not legally recruited to fight, but he has thrown himself in or herself into the fight. Again, the question is, who is this person fighting? Is this person fighting the enemy of maybe his party, maybe his nationality or his group? Or the person is just fighting anybody? So there are so many things there to be looked at. So if the person is picking a weapon, in this case, the conventional weapon, that's the terminology, conventional weapon. And that one excludes machete, knives, and all those crude weapons. And fights or kills, for instance, an enemy of his or her group, then that person has lost the status to be protected as a civilian, but will still be protected under the coverage of a fighter, but not even fully under the coverage as a combatant, because the person is considered a legal fighter. But still, the protection of IHL will look at the person closer to the combatant. So for instance, what is the protection of a combatant? The protection of a combatant is just that the combatant can be killed and is allowed to be killed. Only that the killing of the combatant must be humane, and the suffering must be as short as possible, must be lessened, and the type of weapon used to kill the person and how the person is killed. So let us say if the person is killed through torture, let us say we have had horrible scenarios of such things, in which maybe the person is being shot on one leg, They wait for some minutes for the pain to go through, another leg to be paralyzed, another hand to be paralyzed, one hand to be paralyzed. Before killing you, you are tortured. That is already committing illegality, and that is war crime, and you can be charged on war crime. But if you just shoot at the heart or on the head, and you know the victim is going to die instantly, then that is a lawful killing, because this person is already a fighter, though illegal fighter. If the person were a civilian and was not armed, was not dressed in a military uniform, was not participating in anything, then the person committing the killing or the murderer is already committing war crime by virtue of killing a civilian. But if the person is killing somebody who had already picked a weapon and is already armed and is fighting, maybe has even shot somebody dead, if that person is shot dead, that is legal. So whoever shoots the person is not committing any crime. That is as simple as that. Ibrahim, are you with me?
Dr. I'm very much with you. Thank you so much.
Okay, good. So that is how it works. Yeah. So I wanted to add a bit on the principal neutrality, in the sense that when the sick or the wounded are being attended to by under IHL, and the wounded and the sick are taken to health center or where they give the medical care, which must have the emblem, we call distinctive emblem of ICRC, of the Red Cross, then that place is protected, one thing. Second, we need to understand that whoever is taken inside there is not going to fight inside there, because that place is already considered neutral or neutralized. How? So has the person to be armed? This is the question people ask. No, the person will not be armed at that juncture, because let's say the person may be armed, the other wounded person is armed. If they start killing each other in that kind of protected area, then that one would not augur well with IHL. So they're supposed to be disarmed, because they're only there to be attended to by medical experts, but on the neutral ground. So when they get into the neutral ground, they also become neutralized. But that is just for the moment. So, so let's say that the fact that you are wounded doesn't mean that you have surrendered. You are still a fighter. And you are wounded, maybe badly, but still you can say, if I get that enemy, I will kill the enemy. And the enemy is lying just next to you. You are both in one room. Or maybe you can hurt the service provider, medical service provider. So in that case, disarmament is done, and it is momentous. That means once you are over and you have been healed, then you can go back to fight, and your weapon is given back to you to go and fight. Am I clear there? Now, the question came when, when it was the case of Al-Shabaab in Somalia. And let's say a wounded Al-Shabaab or a sick Al-Shabaab is brought to the medical care center, which is protected. Will the Al-Shabaab fighter be treated? The answer, according to you, is what? Can you give me yes or no? And support your answer, please. This is interactive. Then we are heading towards finishing. Who has a clue? Who has a clue? Hello.
Daktari,
Yes, please.
this is Anyona.
Yes, Anyona.
Yes, I think the Al-Shabaab will be treated, and the reason is they have a right to healthcare, even if this regardless of whatever status they are.
Okay.
Yeah.
So Anyona, don't disappear. Maintain your position. Somebody with the opposite opinion? Anybody with opposite opinion?
Mwalimu, my internet broke and I missed the question. Could you kindly rephrase?
Okay, good. Now, the question is simple. Let's say it's a question of Al-Shabaab in Somalia, and the fight is going on, there's war going on, and there is a protected medical area, a tent, of course, with the distinctive emblem of ICRC, and an Al-Shabaab fighter who is wounded, or let us say who is sick, is brought to the tent to be attended to. Because people who remove them also are ICRC workers. Should this person be attended to or not? So give us your answer, yes or not.
Mwalimu, I would wish to answer this Gladwell. I think the person will be attended because we have said that the tent is
Yes.
a neutral ground.
Yeah.
The principle of neutrality.
It's a neutral ground.
Yes.
Yes, good. Okay, that is good. Gladwell, Anyona, you are on the same side.
If I may,
Yes, please.
I would also agree with my
Tell us who you are.
This is Chelsea.
Children.
Oh, we know. And
Okay.
Chelsea.
Oh, Chelsea, yeah. Please.
Yes, I would agree with my colleagues, but then I will bring in a different point of view.
Yeah.
I will say that in as much as the Al-Shabaab person is being attended to due to the principle of neutrality and then, of course, the overriding principle of humanity,
Yes.
I would also say that it's not as though him being treated means that he is no longer not a criminal. So I would add something to it and say that apart from being treated because he is wounded, at some point, he should also be, arrested. Because I remember there was a class where you were talking about Al-Shabaab. You mentioned that they are, criminals. So
arrested by who? Arrested by who? Or we know?
Okay.
Who should arrest? Because this is a neutral ground. This is a protected area.
Right. It's a protected area. Yes, I do agree, but that does not negate the fact that these are criminals. So I'm not so sure how exactly they will be arrested in a neutral ground, but I believe that they should at the end of the day.
So as per the principle of neutrality, how far are you justified to refer to such a person as a criminal?
Okay, that's an interesting thing. I think I'll ponder on that.
Okay.
Mwalimu.
Yes, please.
This is Ibrahim again.
Yeah.
Now this Shabab who is wounded and brought to a neutral ground.
Yes.
Mwalimu, if he's, maybe we have to ensure that he's not armed. Probably he could be carrying, suicide bomb or something like that to come and finish now the other people who could be there. So maybe that person could still be dangerous because he could be carrying something, so I think first we must be ensured that we must satisfy ourselves that he's not armed, he's not carrying any vest. Or
he must be disarmed.
Disarmed, yes, for him to be protected under neutrality principle.
Okay, good. Okay, that is good. That is affirmed. Okay, I think the majority of you are for the opinion that the Al-Shabaab fighter must access neutral principle when it comes to the wounded and the sick during the combat. And in that case, there is no any part of IHL prohibiting such a person to be treated and to access treatment. Only that the condition is the person or every person seeking that assistance in that neutral facility must be disarmed. And in case of anything, that's not the ground for fight. They will pick up the fight once they're released. And that one, there's nothing stopping them. Eh? Good. Okay, let's agree that.
Mwalimu,
Yeah.
could I please seek for clarification? So, while I agree on the treatment and the right to have treatment,
Yes.
would it also be in order to then say that for as long as the Al-Shabaab is, is seeking treatment in that neutral ground, they're
Yeah.
also protected from the combatants, or would the combatants then be allowed, if they got word that the Al-Shabaab is there,
Yeah.
go and retrieve him from there? Or is that a protected area? And for as long as the Al-Shabaab is there,
Yes.
they are guaranteed.
So that is why we talk of the additional protocol 3 on the emblems, or the use of emblems. You know, emblems are are protected by law. And in that case, being it there means that it is a protected area. I talked of protected areas, protected persons. So no KDF soldier can attack the area because the enemy is being treated there. That's what all it means. And if that is done, then that is in violation of IHL. Are we together?
Yes, we are, but then that creates a loophole, because if I know this is a protected area and I'm Al-Shabaab, then I would go there for protection.
You don't just go there, you are brought there by ICRC officials. Under Common Article 3 of the Geneva Conventions, only the ICRC members are authorized to pick the wounded and the sick and take them to these protected medical areas or medical zones that are, we say, designated only for treatment. It is not that you just feel you are sick, you walk in. No, that's what we call, you must be assessed by experts.
Okay, Mwalimu, thank you for that clarification.
Okay, good. Welcome.
A
Excuse
question.
me, sir.
Okay, please, yeah.
My name is Uzima. I have a question on now that, especially after the Al-Shabaab has been treated, what really takes place after they have been treated and they get well? And of course, during that treatment, we have seen some people, even locally, for example, I don't know if we have seen there are criminals who are normally handcuffed to the bed. Does this also apply to them, to the Al-Shabaab who are brought into that neutral hospital? Yes. Thank you.
Okay, good question also, because they are not handicapped because I told you it's a neutral ground, and ICRC, IHL does not consider anybody a criminal of war because that is now the opposite of what the neutrality principle is all about. If you talk about the discharge, let's say the wounded Al-Shabaab or maybe the sick Al-Shabaab gets well and picks the arm again and goes back to fight. And if this person should be arrested. Now, the question is by who? Because this is not the work of IHL to assist in arresting the person. That's another thing, because they're not even allowed to share any intelligence or to share the identity of the victims of the sick. No. That is another point we need to raise here, that there is privacy, intimacy, and they may know something, they are human beings, but they are not allowed to share intelligence with any authority and with any participant in the fight, in the hostilities. That is not allowed. And there's high level of diplomacy in that. Now, let's say the same Al-Shabaab, let us assume and change the topic. After having been discharged, because the guy now is okay, and picks his arm and goes back to the forest to fight, and comes back now to hit ICRC. That is in violation, in contravention of IHL, and that conduct can be prosecuted. That is how it is, because under obligation, anybody who attacks such protected areas is already in contravention of the Geneva Conventions and additional protocols. Wow. Now, guys, can we agree to stop here?
Yes, Mwalimu. Some of us are having another class after this, and I think we can pick it up in the next class.
No problem. So I think on 4th, we will pick it up again. Otherwise, I thank you so much. Enjoy your weekend. And remember to read, eh? Okay.
Yes, Doc. Yes, Doc.
Okay,
Yes,
thank you.
Madam.
Okay.
Bye.
Bye-bye. Thank you.
Okay.
Okay, bye.
Bye.